Good evening, everyone. Dasari let's unveil hey, we will start with our program now. Zani na hey hunche takara clinical kan syllabus kan tilo tin ngai si practical kota ashing shana hanin lan rem si lo kha zani na online program in special lecture kan nei don ania zani na hianin I welcome each and every one of you, our dear students, and our resource person for tonight, Mr. B. Lalramenga, Puma Enga. Bi Lalramenga niya zan na kan resource person turi ani hi Puma Enga hi zautla nga kwanin anu pui fanaw tanelan ko saa. So he has been practicing, he has a practicing experience of over 16 years. Kumsang nile panga atang kanin kota alo practice to advocate anito chuchu zanina ani hianin hunche takara minlo siam saktheya kan lom ema amasaberin achunga kan lom thu kan soidua tin engeni puma enga kan timenga sarma enga ponia puma enga hi kita district court high court hiana practice de vera chuta chuanin law firm aneya B. Lalramenga and Associates the aneya chuta chuanin junior paria tuna hianin anwa hianin an practice mek boka tin heba ka hianin Puma enga hi court a practice ba ka hianin tuna hian at present he is a legal advisor come standing counsel for Ripanstan dinga legal advisor ni pa ka standing counsel ni boka Ripanstan tin Lai Autonomous District Council te Mizoram State Sports Council le Mizoram Cooperative Apex Bank Limited te heng te hi adin sak boka a represent boka ni ti kha a practice a court case a khoi ba ka kan soitel duatin Puma enga hi Aizawl Law College mo Government Mizoram Law College alani ma Aizawl Law College ani laya law graduate to kha ani zarina hianin a hun lutak minron pe the minron spare the chunga po kan lom matin kan zir lai te po khanin zo du le enge mosha chian do kan nei ni chuanin zanina po hem Puma enga khanin minti sak thei tura ngai bokta ila kema lama hianin he power supply kan nei lawa aboi thak ang reng reng me ma ro chu kan ti thei chauzel tura ngai la tuna chuanin without further ado I would now like to call upon our resource person to start with his presentation. Puma eng.
Okay. Kalom khub mai hey Miss dedicated min som na te zanina atakin kan mutheya and first of all good evening everyone, and I've heard that maybe one or two students who do not understand Mizo language amongst you. So anyway, I'll do the lecture in Mizo, but I think it's better to say something in English also. So if as possible as I can, I think I have to uh, do it in English also, so that it will be easier for that particular persons. So tonight, what we're going to talk about is about the trial in the court proceeding. In the trial in the court proceeding means what the meaning of the trial. First of all, we have to look at it, because the trial, as defined by the Honorable Supreme Court in the case of Union of India versus Major General Madan Lal Yadav, is that it says that trial means an act of proving of or judicial examination or determination of the issues, including its own jurisdiction, in accordance with law. That means in the civil case, that the court has to prove by judicial examination each and every issues involved in the case. And in the criminal case, that means adjudging the guilt or innocence of the accused, including all necessary steps. So that means generally trials commences from the stage of the evidences. That is what, first of all, I want to make you understand the meaning of the trial as defined by the Supreme Court. Chu aum zia chu evidence satang hana in tan ani berani chu trial chu kanan soi fiadora trial hi ko ta ataka en lo chu nin soya soi hi chu har ko ya maro chu the top in simple thing berin soi tum taila I'm not a good orator, and I'm not good in lecturing, but anyway I'll try to make it interesting as possible as I could. So engpolo ni se kantan bob mo pa kan khethiam thoin karinga adang introductory le engemo kha hanti vak na kun po wi omin ka hian kina zo na te po kan theng angin kan la kan chan tur te po oma a tur angai taila hey trial kan an ti chung kan soi tong khan civil case atang tan taila azau angrenga topic ki ipo ni se civil case le criminal case na hlom lian tok chung kan then theya kan khetlang vek thongai nang ni chu final year mo ni tolum ka e chuwang chuanin enga mo chen in zir to in karinga thoina civil case chu kan soeng khan trial kan han soi don chuan heta pleading atang te pon tran khalo ngai ta a plaint kan han ti atangin mi in thu buai a thelu ta kota plaint hi plaint chu kan zir tho ngai plaint chuan enge a contain tur nia enge plaint chuan ina kentel tur enge plaint ni phung ti te chu so written statement al chan na ron thelu ta order 8 ta order 7 chowa plaint kan han tia chumi hnuwa enge in king parties te ka court an ron langta chuan hei mizoram a hi chuan kan thriat tur chu cpc te civil court of procedure te hi ani na angin in letters angin kan zom lo ni chan chu kan mandar civil courts mizoram civil courts act hian a spirit in zom turani ati wang hian tian achi achi ang in ziak dik 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 ang hian kan zom lo wa achan chu dan mizoram civil courts act kana tu lo ve ti wang ania chuta chuan tikhan cpc a stage rang rang te ka kan han pal tlang ta kan ti lo tam ta ko mani chu aizol big ha in confine taila aizol big context atang soi taila mizoram court kan ti me yang aizol han tia chuta chuan in khinna thun thelu ta le la min written statement aron file after filing of the plaint written statements was is filed and thereafter several stages are there like examination of the parties by the court see under order 10 after pleadings are completed in the court then if the court considers it fit to refer it to the lok adalat and other alternate dispute redressal forum then it could be referred by the court also but thereafter the subsequent stage will be like settlement of issues kapoi motani issues will be framed by the court that means from the pleadings of the parties, suppose I am the plaintiff and I raised several points, whether in respect of the law point or whether in respect of the issues on facts, then the defendant side will reply by filing the written statement. And from both the pleadings, issues will be arising. That means issues of fact and issues of law. That means when the material proposition of fact of law is affirmed by the one party and is denied by the other, then on that very point issues will be arising. Om zia chu kein ka thu ka thelu ta lela minaron changa kanin chalta unalai zela han issues karon piang don tani etia ram boy ni ta se ke chon karam min nek katia alelam ka thenno min ka nek lo ama zo khia lsc junior zo ko lom ti ta se ole issues lo piang tur chu tu nge tu ram nge in nek zok tu nge anek tu zok ti ka issues lo ni tani chu chu kan chen thui de lek na lai chu lai chuan try la tan khana poimo tani chu ole chu mi nuwa chuan try le in tan ma khan hei pre hearing ti te first hearing kha order 15 cpc kan en chuan kan hmutani chumi first hearing a chuan court khanan en wangwanga a issue a in hial na vak tur thil piang om lowa in murem ang ani chuan in khin na te po ha en tinan ka khingta ka theno minaron chang ka thenom pan en ram boy ani ta se ka khin na kha aron hial em lo ni chuan first hearing a khan issues po piang thelo tura rel fel thengal ni khan ko tin ngai ve the a rel thengal top me ni ka tiang ani ka chuan a in kokal a in chal tau lai thil om lo ni chuan chu chu issues frame nuwa chuan amaro chu evidence lak te lo ngai ni chuan kha issues rang rang pali panga po ko tin lo frame the rel tur point khani chu mo issues kan han ti chuan kan khathonga those issues framed by the court should be decided all the issues framed by the trial court should be decided one by one. So at the preliminary stage, as I have just said, at the preliminary stage, if there is no issues to be framed, suppose the plaintiff raised contentions and the defendant side, although written statement is filed, but no counter is made in order to counter the submissions of the plaintiff. And at that very point at the first hearing, the trial court can dispose of right away by pronouncing a judgment. But if issues are there, that means in order to prove his case, the plaintiff has to produce all the evidences. Then from that very stage, we can say that the trial commences. Chiang may true, hatatrangan trial kanan ti chu. Alaw nita, kan kriat, nu po ni thonga emi CPC kan ziratrang chuan. Amaro chu, okay, the trial, it starts from that stage of the evidence, and we have to look at order 16 CPC. Chutachuan, it talks about summoning and attendance of witnesses. Okay, list of witnesses should be submitted by the plaintiff side and from the defendant side. And the court may permit to call for witness whose names that doesn't appear in the list, but it should be at the discretion of the court, trial court. Chu summons the witness list ka thelu ta chung ho chu liana moya thanga hi ke chu ka witness ka ko turani ka tita defendant side pon an thelu dwenga ka kanin surprise thut thut don lo ta tina ne chu thu tu ka thu thelu kha kal ka ta na ka witness ka thu tu tenan soi tu ale lam side pon defendant side pon aron poranga list khan thelu tanga okay, thereafter order 18 will come. That means production of evidences by the parties in the suit. Then I have to produce all my witnesses. Suppose I, myself, being the plaintiff, also have to give my evidence before the trial court. That means what CPC says is that if I myself, being the plaintiff, have to give my evidence first, then at the first place, so to say, I have to give my evidence first. That is what CPC says. And thereafter, my other witnesses will uh, file their evidences. See, prior to 2002 amendment, what we used to do is that they will record all the evidences of the witnesses before the court alive in and record thintani chu. Then witness will come in the court, just like we have seen the movies. Witness will come, and he will personally he has personally personally has to attend the court, and his evidences will be recorded. Okay, while explaining the nature of trial, we have to refer to the Evidence Act also. Evidence Act po also itelangay ta chuan the way evidences should be recorded is that by conjoint reading with this CPC and the Evidence Act, what we have to know is that witness comes to the court prior to, I'm talking about prior to 2002 Amendment Act, CPC. Witness has to come personally before the court. His evidences examination in chief will be recorded. Examination in chief kananti kachu ka witness ina an favor asoy khani. Suppose I'm producing Mr. Liana as my witness number 1. That means he will depose, he will make a statement, he will give his evidence before the trial court in my favor. That is examination in chief. Okay, he will be cross-examined by the other side, by the defendant's counsel, defendant's lawyer. That will be the cross-examination. So at 2002 amendment ma chuan examination in chief po chu an record vek thin ta ni chu kota alive in ti meyang chuan chumi nuwa chuan cross-examination ka defendant ukilin aron ti ta a thu zot le ta just to disprove the examination in chief, what the witness has stated in the examination in chief, just to disprove that cross-examination is necessary. Then thereafter, if necessary, re-examination can be done by the plaintiff's counsel. Khatiyang khan trial kakaltani. Amaro chu 2002 amendment nuwa chuan CPC kanen chuan examination in chief kachu affidavit mangina file the tani chu. So we have been practicing that filing of an affidavit, particularly for examination in chief. And my witness, I being the plaintiff, my witness will be submitting an affidavit of examination in chief. But however, at the time of cross-examination, then that he personally has to appear before the court for cross-examination and re-examination, further examination. At yang halo tani chu chulai chu a proceeding chu ni tani. okay ke plaintiff in witness pakhat pani pathum pali panga po nei tela cross examination an tianga ta chu re examination tur om chuan ihan kan re exam lenga further cross examination polo thea khang zong zong a zo hun khan. Thereafter, after closing of the plaintiff's evidence, defendant's evidence will start. That means just like the plaintiff's producing the plaintiff's witnesses, defendant will also, if he is willing to, the defendant is willing to give his own evidence, then first of all, he will give his evidence. Then the procedure will be the same. And thereafter, his other witnesses will follow. Chiang mai tru kha mi kha akal phung chu alo ni ta mai ta ni evidence kha chu chuan emi cross examination in chief kan tia hi chuan e tian a practical chuan an soitela affidavit a kan thelu ani wang khan an thu tuina athu soya po kha athu riat ang kha lova social theory lo khani ti me yang azia ka affidavit ina tho thelu ta mai ta ni and the alive record lai chuan a ukil ina zo ngai nga sang ni pani malam te chuan ni ta se a ukil khani thu riat ten soiro le tinga leading question na zo the ta mi lo ta ni chu try la chuan examination in chief re renga chuan example han petela ka witness kha ikhanin thu ka zo ta ni ukil ni na ngin examination in chief lo record don tela chu ta chuan criminal a chung kan soi chhawanga examination in chief ka affidavit in a thei ve lo ta criminal case ate chuan civil a chu criminal case nakin ala chiang zo nga examination in chief a chuan kan lead thei lo ta entinan ka thu zo kha hei hi nang chuan helai e thil khen na hmuna hian I oma I local ve lo thleng chi a chumi chu tiang ka tiang chuan anin sulai te lo hmuwa chumi hnuwa chuan nangpon enge avakai tho tu ate tanga adikem ti tela asoi tur kha ka lead ta ve kani yes or no che na chana ngai to ka tiang examination in chief ate chuan arem taloni maro chu cross examination a chuan athiang zau tai ti meyang relevant question angte relevant fact and tinan ka lead theta ni chu tu na ka han soyang khan leading question ka zota an chan na kha yes or no ang che ten ka chop chop theta azo na zong zong ka thui de pon ka siam theya chuan ka lead theta athiang ta ni re-examination lo pian le theina chu defendant side in cross examination an antita chumi hnuwa hi in kokal examination in chief a asoi kha cross examination a hian chu tiang chuan ron soi le sia engvain nge hela hi soi fiate ti theinan chi khan re-examination a chuan a limit to ta ni chu ani lo chuan tikhan anin cross to na in zot to na evidence ka top thelo ringot don ta ni chuan evidence ek kon fel fai tegin a soita soinon le examination in chief a witness in a soikha cross examination a let I adverse token lo soi le ta se okay if examination in chief the statement depositions made in the examination in chief has been rebutted disproved in the cross examination and for that reason if explanation is necessary then that means the plaintiff's lawyer the plaintiff's counsel can ask questions at the time of re-examination but only to explain and to justify and to explain that particular point right chu kal phung chu ni ta ni try la chu na poi mo khop meya chu tiang te chuan ka du ei ka re exam vele dono ti hun na phur thu ta ti chi khani lo ta ni kanin hial fo ni ko ta po e chu evidence act hi ka king nge zel evidence ka lak do ni chuan yang chuan judge in min thel tur ni ta kan ti fo ta ni chu poi mo khop me helai bor hen cheng re do ta mai la criminal la tan pu han apoi mo em ka tia a practical hian en theiu la chuan nge a chiangin karinga tin CPC na soi tren kha chu hey entina soi fian tu mela fia che thegem wer khlowa zo na ka zo ta ni chuan zo na ka zo kha ukil la in zo na ka zo ta witness kha aron chang ta aron chan na kha ka zo na vatel lo kha chuan a fia lo ve thei ta tani chu non ka zo chu wan tak chuan CPC an fel fai ta ga lo then chu hey tuna zanina hun kan man donin ke po kan en non ve le ka hiat bel le chu thoni chu angai nom ka tia ka in refresh ka ti me ya chu ta chuan zo na kan zo le a chan na ang zong po hian a record vek theni evidence hi a fia ani chu CPC hian atum chu ataka kan han practice chuan kha zo na kha alan tel lo chuan chan na ringot kha fia lo ve theni chuwang chuan in zo na le chan na ne na record the dan poi order 18 rule 10 chowa te hian lo soi vek me a tin code po hian in enge rule 11 chowa po hian order 18 rule 11 ate po hian hei code hian eh ka zo na te ukil plaintiffs ukil ni na in kalo zo ta defendant side ukilin aron object ta khati objection point po kha evidence stage akan a record the vek ta ni chung te chu game rang rang kan lo mai thina ni dik ta chung ke ni pun kan uluk pe lo thina ni a chuan hey kan en nun le hian I remembered that one point of time while I was doing the cross examination regarding one witness in my one of my cases, and at that time the witness, although she pretended that she was the victim of some like offenses, serious offenses against women, then she was acting as if she was really the victim. Then at that time, we also came to know from other reliable sources that uh, she wrongly blamed our client. She wrongly blamed the accused, and she wrongly accused the accused person. So at that time, after at the time of taking evidence in the court, then her character, her behavior, like was not, how to say, was not in agreement with the accusation that she made. Ama ka conduct kanin kan character kanin kan, hey enge a serious jong si lo ni atira chun I intingui Veomero during the time of evidence, then she was not. I also could see in her face that she didn't suffer at all. She didn't. She was not really a victim. So at that time, then she laughed. At that point of time during the evidence, then I requested the court to record that the remarks on demeanor of witness. Anui thuka. I requested the court to put on record that she was laughing at the time while I was asking some questions regarding her allegations to the fact that she was suffering so and so, she was the victim, and she was quite depressed. Chuan ayin ko kalta ni chung te chu hey CPC te hian CRPC po alo so ya try la chuan khang te kan lo uluk lo thin ka ti me hey alo poimo ka ti ni chu ka khan na ki na han kan point out don ta ni chu atopa kan argument huna khan chulai te chu enge angai nom ve em ni chu ataka haning lo chuan ti me ang ma se ko thi chu trial chung hi reya and then lo observe tawla voi khatin observe chuan ko ta a thalia de kan witness dang te po di lenga chuan abung nu ya han ti kan riat thiam chu a har mai thei chung lai te chu kan soilan le du ni se chuan in kan witness tu mo hi zinbo tur ramhla dewo om tur te lo ni ta se trial intan ma ho po khan adik ta chuan ama kha exam evidence ka alak thot thot dan te po hi order 18 rule 16 ati hian soya in court hian the witnesses who had already been examined can be recalled by the court. So that can also be that power under Rule 17, Orders 18, Rule 17. That kind of power can be invoked by the trial court. So, okay, then during the trial, what the court can also do is that the trial court has power to order any point to be clarified or to be proved by way of an affidavit. That is under Order 19. That is also one of the, how to say, important tools that court can implement during the trial. Because suppose one piece of evidence is very much required during the trial, and in that case, the court may ask any other person to make any statement by way of an affidavit and to produce before the court, then that can also be used as an evidence. After all evidences are recorded, completed from the plaintiff side and from the defendant side, and thereafter the trial court has to make a decision. He has to that the court has to pronounce judgment, and it has to be pronounced at once. And prior to that, oral argument has to be conducted by the trial court. So, and based on the evidences on recorded, I, being the plaintiff's counsel, has to present my case. That is the oral argument, summing up of the case, so to say. And from the defendant's side, defendant's counsel will also present the case based on the evidences on recorded, evidences on record. That means we applied photocopies of the depositions of the witnesses from the court, and we studied the case. And based on that, we are also focusing on the issues framed by the court. Court in issues of framed tani. And on that basis, we are also at the same time looking at the evidences on the court. Then on the basis of that, we present before the court that okay, these evidences recorded are in our favor to decide the issues being framed by the court in our favor. Tiang han kan hiel tani chu ve kalai base han. Chulai chu argument ni tani. So written argument ka court in rem tini chu written argument po concisely we have to prepare one written argument. Both sides have to prepare, and we used to submit before the court. That is also as permitted by the CPC. Okay, after that, on the basis of all that, then the court has to make a decision in each and every issues framed by the court. Then judgment has to pronounce. Judgment kanan tijon, that means reason for making a decision. Judgment kanan tijon. Okay, that is the judgment. And decree will follow. What is the decree? Decree should be in agreement with the judgment. Decree is that actual direction timayang made by the court. At as hey judgment a chuan hey kasiam kati chan chuni issue number 1 ka decide chan hi chuani chu asoita. Okay, thereafter decree will be drawn. Decree ka pass le ngai ta kha decree a kha chuan chu mi ni wang chuan plaintiff hi ka chaktira defendant hian ram hi alu adiklo ni lo chu asan ro se avati na tak lai ka soitiam da chuan decree definition a chuan finally adjudication all the issues involved, all the questions to be dealt with in the case finally disposed na khanita. Tulay chu trial kan tika na huam huam chung khani alandan chu ni me adanga chu soitu tam taw peng thuilo tai la ka ti vain trial ni wang han. Tulay chu civil bi ka chu kan du tok me do no mi ka ti do ni kan post sok do en ka lo miss ne na.
Puma eng I tikhanin chunzom la dule atop lama zo na le chana ka chu hun kan mang mai anga tero.
Ole, okay. Lo men ni chuan criminal case and kaltai lai criminal case chu a trial hi adang le deu tani. Okay, anyone who can answer me then anyone who knows the definition of warrant case hi enge ti min chang thei no ma'am. Someone's case ne na omzia. And participate very to get in zoton mapon. Nghe kan la khachi alo deu vi. Nghe CRPC kewlo hi chuan ria tharo ke warrant case le someone's case kan riat ma sakngai ka riani. Hey warrant case kan ti chuan IPC kan en chuan IPC a khan a khemna an tan hun the zatte imprisonment with death, imprisonment for life, imprisonment for a term exceeding 2 years ang do tani kumsari tite. Warrant case kanan tia hi chuan which can be punished with death, imprisonment for life, or imprisonment for a term exceeding 2 years. That is the definition of warrant case. Mo kum ni noilam zongero hachu that the punishment which is less than 2 years are someone's case. Someone's case le warrant case ka trial dan wang kan differentiate na chan kherpo kala ek khefia taila. Okay, hey kota case aron lu da ni chu criminal case chu section 190 CRPC kan en chuan magistrate in cognizance alak the dan kha soyani kota case chunzum jail tura trial tur te alo pom the dan kha cognizance alo lak the dan kha soita. pakhat na chuan complaint kan thelu ten ani ta he defamation te po private complaint ang ten an lu ta in then khat po complaint angin e eng mo case danga te po private complaint in an lu ta chuan adot le chuan that is upon police report means then one suppose one lodges files an FIR, that means FIR should be uh, entertained by the police station, and then that from that very point inquiry or investigation will be started, and thereafter after investigation is completed, charge sheet, that is final form, will be submitted under section 173 CRPC, and from that is the second point, the second is point um, against which the magistrate can entertain, can take cognizance of the case. Then thereafter, the last point is that upon information received from any other person and other than a police officer, and upon his own knowledge, upon the own knowledge of the magistrate, then case cognizance can be taken. Okay, cognizance alak nu kan, then thereafter the framing of charge will follow. Tian kan soi fienge amol mangdo zogin mi en lo manda ni mi police FIR ka thelu ta ka thenom pa in kan gate alo ti cheve ringot meya FIR ka thelu ta house trespassing te lo ni aron lu mana wang ten ta chuan police in an chui ta chuan an chui na report ka charge sheet kan ti ta final form section 173 CRPC noya chu chu ko ta nan petani ko ta thelu ta magistrate khan chu mi nuwa chuan section 207 noya comply ngai ta chu om je chu charge sheet copy ka apetani accused ka he hi an pu na che nia ilo chiar venga he charge sheet copy hi final form police investigation report thi he hi I don tur ni thlonin ya thlonin a penga chumi no jon charge frame ngai ta ni charge frame om je chu kha accused ka ko ta ron dinga aron din le chi khan khami enge documents well charge sheet copy pek nu khan code khanin an pu na chu house trespassing ania okay theft case ania 379 na chumi khami chuan thil ti solin an pu che a ti toite soiringot po kha athiang lo ni chu thiang lo ti meng section 211 le 212 CRPC na soi chu achiang fek fok tur ani ti charge frame a hian magistrate hian azo tanga a hilanga chumi chuan pu na che nia chuta chuan chumi dar ka ra chumi nia chuan chu tiang kha tiang tia pu inia a khem na po chu chu ni chiang takinas azo tanga yu ipo mem ti na zo don ta ni chu whether he pleads guilty or not, the accused should be asked, and the accused, if he says that yes, it is correct, I'm guilty, then that means he pleads guilty, and right away he could be convicted by the court, by the magistrate. Okay, so then prior to that warrant case kantia chuan kami charge frame kanti ma khan warrant case means the case, the offense wherein the penalty exceeds 2 years, as we have just said. Chumi ang case renga chuan if in the warrant case prior to framing of charge, opportunity of being heard, chance of being heard should be given to the prosecution side as well as the accused side. Omzia chu tianga tak chuan kanin hial ve thei ta thin ta ni chu ke chu case hial na turo mi chuan kan hial ve ram zela example a chuan pakhat kimi government high school bulvela ke ni gar mana bus a hianin bus battery hi ruk tu ma hanan puni kan din sakha kan na junior ve du lek line ania so da chuan theft ang khan ron charge ta theft case ka a definition ni a ingredients kan ti hi IPC han NCN angai ta ni tunami framing of charge ma kanin hial thena lai soifia na me ni chu a fia dewin ka re NT na nenian chu da chuan ka battery ka charge sheet kami final form kan ti an ron zia dana chuan battery ka ahira ma se battery ka chu ala son lova ru ka tuma tani bas chunga chu na luta maro chu battery ka la son lova ka battery ber kha ruk tu rom theft an pu na chu ni ta abas ka chu a ruk po khal chole ruk khom chong lova maro chu theft definition en chuan a ingredients IPC kan en chuan mi phal na lova lak son chu move fa kha o mangai ta ni chu lak son kha awm na ngai kha na lom sia battery kha chuwan chuan church frame ma hian 211 le 212 church frame ma hian argument a han ke chu ka nial ve ta ni chu a section ni chu a boring a section ti soiloya 239 vela ning ka ria kami kanin nial the na lai na kha chu ta chuan e chumi ground a chuan kalzel na tu there is no ground at all to proceed with the case, because if we look at the theft definition, that means it has to be uh, that the particular item should be moved from here to there, okay, without taking the prior permission of the owner of the property. To me too, but if that moving of that particular item was not there at all, that means there is no ground for proceeding with the trial. With there is no ground for framing of the church. Then I are good on that point. Then I succeeded. Kami hanin church frame ma in lakha alo omtani. Okay, thereafter, if the magistrate sees considers that there is reasonable ground for proceeding with the trial, then he will frame the charge under 211 212, and by explaining all the nature of the offenses of which the accused was charged with, and thereafter the consequences which could be faced by the accused if he is convicted and if he pleads guilty, that will also be explained to the accused. Okay, in spite of that, if the accused pleads guilty, then definitely immediately he will be convicted. But if he doesn't plead guilty, if he pleads not guilty, that means evidence will start. The prosecution side will produce all the evidences to prove their case beyond reasonable doubt. That is very important in the criminal case. Beyond reasonable doubt, all the witnesses will have to depose in favor of the prosecution side, and each and every witness should be cross-examined by the defense lawyer. Okay, chuchu akal phungkhani tani. It is somehow similar to evidences that we have just talked about pertaining to the civil case. Akal phung chu examination in chief, cross-examination, alo pangay, alo in ang tlang loma. Alay khachu so ithulu tuk to lo mela trying kariya tin chu magistrate a trial alone niya chumi trial kananti evidence azo vek nu chuan under section 313 the trial court can also ask at any stage, even during the inquiry, even before the evidence starts, then the trial court can ask the accused by invoking section 313. Several questions can be asked by the court. Amma khana zot vet he just 313 examination kanti te chulo niya. Okay, by taking all this T13 examination and evidences on the court, then the trial court has to make uh, the finding, has to give the judgment whether the accused should be convicted or whether the accused should be acquitted. Acquit to convict to teka. Arel don tani chu chumi zir chuan tikanin abba ka chu 360 lai te chu soidu to lo meira ka trial lang chu nia tin atop na kan highlight joy du chu. That is the trial before the magistrate. Trial before the session court, it's a little bit different. Chapter 18 where CRPC kan huwa. Chuta chuan atir berayan session court kan ti chu court sangber khani high court ti lawa chuan trial court. In kan riat tel tu kan zolok du chu trial kan ti high court a chuan thei velo ni. Witness te ko khatia ti khama ro chu trial high court a theina ang dana chuan hey election petition kan ti a chuan witness ten ko via high court pon ka tiang trial chu kalpui ve ka tiang ni lem lo chuan CPC le CRPC na soi china chuan high court hian trial ati lo ni ti ka riat turani so chuan trial court kan ti chuan criminal side a chuan session court IPC kan en chuan murder case te chu session court khoi turani ti lo in clear thang hal vekang tin ka tiang tribal by a magistrate te bolo in tinga offenses rin chuan chuan magistrate ma trial ani kan soi kha warrant trial ania warrant case trial kan soi ka summary case trial a chon session trial ka soi ka lu main kan soi phel deu noi ni jo summary trial omle summary case chu a hrem na kumni noi lam pangani khan e kan hriat tur chu a hrem na kumni noi lam ani kha chuan a toy ni chu trial kha accused court an ron hruaya iti suali chu chu nia chu tiang chuan an pu che I pome ma tia zot ngal to pang magistrate khan helaya in hial na chan spec le ti vela pu kha kher lo ani tiang chuan a toy ni session trial a ro chuan summary kha chu kalsan te la session trial a ro chuan public prosecutor in a open nga case enge ni ti te soyanga chuan in hei public prosecutor nge nga ya app te ka chu assistant te ka chu anding theilowa chu ta chuanin in case nge soinga chu mi hnuwa tikhan charge ten frame nga mo a plead guilty chuan accused pon convict nga chuan amaro chu prosecution adang lam hret na chu kan soinga rei to lawang prosecution witness anzo hian magistrate ma trial a chuan defense defense evidence accused lam khan witness ani ve chuan aron phor vele ngal mai amaro chu session trial a hi chuan session court trial a chuan prosecution evidence zo khan court hian en phot don ta ni chu prosecution evidence ngau tang khan case om loem accused si chu me the dan o mem ti kha chu ta chun chu me na ta an case chiang lo me beyond reasonable doubt in and proof the don chuang lo ni ti chuan a chu the da tla tani ma se chu defense evidence ron in tran ma pon amaro chu a proceed zel ground kam hue ti ni chuan a defense evidence ka ko wang accused in evidence aron pe velenga chu zong evidence zo nuwa chuan judgment a puanga chua acquit tur nge nia convict tur nge ti te kha aron conclude don dani so the chu then all that I can say is an overview of the proceeding of the trial. So I'll just hand over to Miss.
Yes, thank you so much Pumaenga I kota kumdanga chuanin I sarma enga ponaron soi angkhanin trial observation ka kanhan kal thida mar zo soi angkhanin tum ni kan van nei chon tum ni te kan kala ani lo chon tum khat chau te kan han kala kha tenga khanin voile khata trial kal pung shim ma kha voile khata kan han witness vek thailo ni khang zong kha zanina a theory in mo court anti ang thap thapin min ron shil theya alobom hle maya I kanjir lai te po students te jing atang po khanin zo du le sha chak deuh hlek lo nei te po kha om theya so if there is any question or doubt or han soi zau te po nyang chu ECRPC anjir mek thawa a second part kha criminal law khanin khanin inge mo zo du kan nei ponin yes I tuna interaction hun kha manglo kang o kan ming ka chiang takin kan soyanga video on the chon on sham ni sela rem lo pon kha ka chu poi lo ba kan ming ro te ka chu chiang tak khanin soi thungila oh yes the house is now open for discussion interaction or any question. Yes, anyone? Hanzo bel du em te kan nei lem lo mi aldrin ate sai mi ngate ho te kha in bomoi ve. Yes, sai min thang ate.
Hello sir. Lem lo he achiang ve wing ka ria a chan chu ni zana po khatiang lam pang kan longai thak to awang khan han zo bele mem tur ka nei lem na.
Yes, ben apha ben le ma enga kha.
Miss Jamila Risang 6 semester kanya asar ma enga kha kan zot lo pang amol the ang berin mol mang de ko sia chak ve me ja ha ke te mu mal the si ro kan zot lo pang tun na ya social media an case ka chuan traffic thonga I criminal complaint no mani social media min chu political issue te pon kan ti the ome tu ta chuanin criminal complaint so lampang chim lampanga umta an case min vel ka chu soi lang lo taila ta khanin an mani a victim te kha a khoi jok accuse te jok kha khami court trial lai khanin social media khanin thil an la post unani an case ka social media anita kha an lo chana po kha complain na chan po kha kha a thei re nem trial court an nei la ya kha tianga a social media na tal na view me kha a thei re nem ti kha a mon ma theng berin kan zo te ni chu
A case chu ka khachi lo na ti me ang a ing per nge ti chu ma ro chu soirem lo chon in zot kher lo te la ro chu khiat thiam the me a hetianga social media te le news item a polonita se hey contempt of court vani thei tur ang chi le va soi rem chi alo court ina judgment pon ma puwa enga molo soi chiam la ang chi thil te ani lem lo chuan a isu berakha le ka riat chen lo vain ka soi thel do me the ka lo ma ro chu khami kha enge chiang taka CRPC anga te CPC polo ni se danina abar na ang te kha a mo vio ati me yang amero chu khami a isu berlain khilla ya anlo post ta enge mo kan lo soi le ni chuan khami kha criminal case lak the ni chuan church at le the me a case danga po piang le the ya chuti ang chuan ati me theyanga amero chu chumi chu ati lo top tur ni e abare it is totally barred by law that totally barred by that particular provision of law ti anga soi tur chuan a har sat karing ka chang fi em ka hello le
Okay, thank you, sir.
Hello, sir. Tôi sẽ tìm bó.
Ma eng sai ro.
Sir, zona pani kanaya na china enge case pakat tun ma bus battery ru kan tumti example iron man laya kanin tinan theft ruk thil ruk tuman puta amaro chu theft definition kan enchuan move lakson naka a property ka lakson ani lo tani chuwang chuin proceed na chantur omlo tin in here thathe tikarita khata kharentina ni chuin trespass to property ka a thei in karia mase a cause of action a khan ziatel ani lo wangin ka achak ta lo tina ni theingem chuan panina chuanin etinan khami examination in chief te cross examination velate khami stage a khanin witness te ponise ama apply na ngai poka khati sorry nge a victim ponise witness an vethita an thu soi thak dang lam hi enge apoi thein viona enge ai effect kalai kha ka zona chu ne
ya pakhat da kha chu adika hei case ayo te po le sarkar lamsai ta anu kil te pon fin chuan theft ringo ta kha book na tur khani lo ve thei tlat reng ani tuna property ya mi property anwa nge damage cheng som machin lek damage ang te po kha a book theya book nuai na tur kha om thei soyang khan kong rang rang in om thei ta tin attempt to commit offense po om le theni 511 po nan book le theya 511 ni chon a khem na te kha nge mun li thena mun khat nge ka chin che lo ga en le lo chon khang te kha om vek ta ni chuan khami beran lo book to lo chon ke ni chon private counsel lawyer anga chon advantage kan lo la ve thin ta ni chuan ukil le lam saita a fing le a tha an din po le hian akhir tareng ta tin case ayo te pon fin chuan code chuan 216 CRPC section 216 kanen chuan church can be altered at any stage ati chuan a add theita ni code ngei pu khan a code po kha alo stick deu chuan ti meyang hi chu tiang kha tiang chuan ania ka add te chumi section 511 attempt to commit po ka add te emi a che dan tanghian mens ria atum na kha omsa der to lom ti pon alo at the tani chuan khalai kha chu thil om the ve gani isoi kha dik khop me maro chu ka khan lo ti lo hi chuan advantage kan lo la thina chona pani na kha evidence a an thu soi kha lo disprove le ta se ti na deu me
an thei thu soi ama lo soi to ma se an thu soi thak le kha ta thin ta ni in thu soi in kal la ya kha ma chu te zo na sai ya boina chu te zo na sai le dei si ya ti la ya kha ka nge apoi thui thei na lai
okay chu apoi thui thei na lai thin chu tuna plaintiff tan khan emo criminal case apol uni se prosecution side tan khan witness pakhatin chiang taka amu thu kha lo soita criminal side tangin tila fi zo ko me tuna a volai ka mulom titani case pakata chuan okay a volai ka mulom atia thinri min sual khan thingfak in a votop mai ni a vot hlutop mai a chu a hliam tur loga na chita accuse ka kan din puya chuan a rei le do to ka chiu chelo na ma se zo na pakhat kan zo chu cross examination akan kalai mun ka thingtang ve ania ti mayang emi street light kan tiang po omlo an mani anon tlan na le an in chona distance te ka tikhanin kan zo ta thim tham thim veka chuanin khatiang anga uit helaya pakhat dingina avot lai tak va muturang khana ni lo tatlatani chutiang chuan ka mulom ti ma se cross examination a athusoi kan thria sakle si chuan beyond reasonable doubt ta na proof tur khan prosecution tan a evidence kha omjenei lo ni tatlata chuwang chuan athu thla ke mo athusoi rin hil omzong kan no thiat ani chun kha poimo na chu ni tani chulai chu defense side tan chu na poimo ta mani chuan ka chang chiang mem le
sir belum
oh hello sir ka tong in che thei tero mem
Yes, Arjun.
jin zo than moi ka ne mo sir ama sa lecture pek dan ha professional ka ti ya i she thi mo ala ngai nom ka ti khopa ti ra pe zon zona ka nei lo lek lek mana ka ril ruwa te chuan kan zir tir tu ron ni long chon ma kan ba son le zo lon em ka lo chu ka soi ma sak du chu ni se ka zo chu CPC noya supplementary proceedings hi ka hriat so lo chuan ama provision chunga ve khan enge limitation in ziak lo ni hei hi asan pain limitation om ve em le nge ni a court discretion nge dan na ran chan thum ti vel kha nin ka hria so lo chuan om zia chu i court in judgment and order at chuak to a decree at chuak to amaro chu i parties khan in khami judgment be chan khan anti tur mo phone khan hlen chuak to si lo wa e lam tan khan remedy om le chu supplementary proceedings chu ta ma se kha internal lo file le lok lo ta se limitation in a bar ve ka zo na ni
om zia chu limitation act kan ni chu ni ti khan claimin kan ka hriat chin china han soi tela karan kal zau de utakla limitation act tina soi chu special act angte CPC po special enactment thonia a procedure code in kalma sela act thoni meya adana khani me legislated chuda chuan limitation act hian special act tina time prescribed anei lo ni chuan limitation act applicable vekanga ti tani jo chon CPC a po entinan chumi hun chung chuan ti le turani file le turani khatiang zonga soi ni chuan CPC special act ina soi kha kan ring menga amaro chu nilowa chu tiang lo omlo ni chuan limitation act kan refer ngai tari chuan application ang kan lo file ni chuan generally chuan soibik te application ane ho zinga kami limitation act in chuan a top lama han schedule om tani kami kha art schedule no article 1 2 3 soi dot ta entenan thuro che probate tur chuan chumi kami ti kha chiang takin omlo ta ase mizo namdana 2014 amol mangzoi soitela dana chun kumnga an thi tagin lo ti van kumnga kan ring meya yandeu che chon CPC in a soi bik kha alo omlo ni chuan tuna I thil soi kha application form but in the form of application anga kan file don ni chuan that means CPC limitation nekta chiang taka inject fa omlo ni chuan 137 anin ka hia tuta chuan article 137 a schedule kan 3 years atitani chuan 3 years chuin kan file anga in tametani suit ang bok alo ni chuan suit te chu time prescribed time lo vekta suit zir khan a schedule hana soile limitation actin khami a soilo lo ni chuan 113 article 113 a 3 years atilea chuan chuan khami limitation act kha kan rin tur chuani tinani chu heta a special act ina soilo chuan okay welcome
Yes.
Sarlaram emoi zona pakhat kan nei so first appeal kan ti te chan regular second appeal kan ti te hi high court da appeal kan ti ne han in angem le ni ai an lo chan ni an lo na
okay hemi CPC len chuan appeal against a decree atidani decree da chira kan soi to mo judgment chu court ina decree aron siam na turtan asoi fia na judgment kha judgment lo de judgment and decree te kan lo dita chon tuna hian chumi tunai izona kha chu rameng moi zo na refia tur chuan state rang te hian civil codes act te kan lo nei ta Mizoram bi ka chuan Mizoram Civil Code Act 2005 kan nei ta ni chu chu enge omzia kan ti chuan court in do chho dan a hierarchy soina khani ta ni chu poimo te mem ni chu Mizoram bi ka chuan court hiam ber chu tuna hianin amendment to nuwa chuan civil judge alo nia civil judge hian a khoi tur ram thu boilo khoi down ta se civil case a mo ram thu boile rowin chu polo ni se kha athu a issue kha subject matter kha nuai nga nuai lampang nuai nga pelo kha civil judge in rel tani chukan soidu na chanchu khoi nge appeal jok tu ti soi fiana ni ta ke civil judge khan nuai nga nuai lampang cho rel theita chuan civil judge ro rel na lo lung oi ta lo taila ke first appellate court chu district judge ani chu senior civil court check 2005 ina soi fia dani ta mase senior civil judge chuan nuai nga atanga chunglam zong khor tel po ni selo rel theita ni chu subject matter kha chu tiang angani chuan senior civil judge ro rel na kan lung oilo chuan chu nuai nga chunglam atanga khor tel limit omlo chunglam ani wang khan nuai som han pel lo subject matter ni ta se khami kha khami chin ani chuan senior civil judge ro rel na po district judge kan appeal thenga je nuai som lo pel to chuan high court nge ngai to ta ni chu chuan first appeal kha entinan civil judge ina ro rel na kha district judge kan appeal don chuan first appeal chu district judge kha first appellate court alo nianga chu section 96 CPC ina soi angani ta first appellate court chuan amaro chu district judge ina rel na kha kan lung oi le lo ni chuan second appeal high court kan file ang chu section 100 ta CPC kan mulea maro chu first appeal ka high court ani ve theina zo ke ro chu senior civil judge ro rel na nuai som chunglam pang value subject matter khanita se kan lung oilo chuan then directly we have to approach the high court as the first appellate court chengam kan so fia
Yes,
me
sir.
han
Yes, midang enge mo hanzo bel du nei te kan omem hanzo le du emo du tun bak lo hi chu puma enga hi heti mai mai hani mu thei kher lo mai thei anya o mi boy ta kanya tu na po hian champhai tangin ron zin ho de chawa ke zan han attenda katire ren khania zanin po hi most of you may be wondering why we are having this program on Saturday night. It's because puma enga te courta ni tinan practice zana chon ke zan lo in study ve duwa mo atu khai court kal tu ne district court an lo nei boka kamini wang khani hun all kan nei chung kha kan grab ve kar le a program om chawa in lo sports chho tu ne khan chu wanga zanin te po hi hun chep tak kar ron ti kha kan ne chu wan chuanin zo na kha mol mang le ho de kha om nya lo nya I connect experience kan soi ve du mai me chu I kan LLB kan zir zawa kan han practice khanin puma enga poi ka shil thawa hetia kan zir tu na te chon in van nei lo to kan mo ke ni te chu kan zir chwala te chonin enge ko ta intin ngen kala intin ke sakal intin kan register mo pesh kar hi enge ti te po kan shengai lo shim kan han kal thora kan senior ten min tira ni lo pon kan van nei chon kan zuya mo khatiang khane tu na chonin atakin engki anron chop chwa sak cheu anron shil fia dab cheu ko takal dan le dan engki makha a practice world le a litigation le heta kan zir hi in an lo na lai tam tak om wang hianin zo na mol mang kha theilova in zo du chuanin tun hi chance thata kani I grab this opportunity kha kan ti ve du ni chu thanem ngai takin mo yes is there anyone else unri lo te kan le ang
la chang kang vak khamai chong lo ne
nia I share lo ve thei de umenia thil hi mo share lo zong tak hi chu kan zira wang le ke ni po kan zir ti ra ma se ni tin kan in chiara puma inga po tu na zani na ka in bo se na lama ka in chiar thara ti ang ka ti ang zel khania oh yes ma enga kha
oh sar chinkar kaming ka sai lo silal eng le na kan ya tuna mi sina aron sai athuma lamaron sai zara han rilwa zona ron luta tuna aizo life in practice ta di chuan hai ko ta te point practice ta ma se champhai kha di khan inan kal le de yan ding le de thu boxia khlai kha intina ne ukil hemi license nei to elo to hi chuan in india ram pung poya du du na practice thei ti lai kha chu kan se tho ta ma ro chu tina district pakhat ta khatia in concentrate top lo khan tia nge dang a hian du chuan in a practice ko zel thei case te po take up zel thei ti na mi
adika hey Mizoram big chu le hey high court rang state tinin high court nei tur ti te constitution in soima sen nei vek thei chu ni ri lowa anin tom ta Mizoram te po enghan Guwahati high court noi kanum ta chuta chung Guwahati high court rules rang khan an lo nei rang vele dia ni kata hana soi chu tuna kan high court noi court niamum zong tle high court a te chuan ni se khami high court ina outlying bench kanan ti mo aizol bench ti tele bench dang a huam china te ka chuan kan vading top the me ta ni ka chu in district dang a po Mizoram chunga chuan vakalat nama kan ti ukil roi na kha kan client ten an thelu chuan kan ding vek the ta me ya amaro chu entiran ke hi Delhi high court azu ding don tela Guwahati high court rules ang no nei ve ni chuan tuemo khata Delhi ha ukil kha ka associate kan ti meng ka in pui tir a ming kalan tel tir ve te lo ngai ni chu chungte te chu rules khalo om rang ve le ya Supreme Court ate chuan filing po advocate on record in an ti lo ngai ya in adin to po kha ka chiang chelo na ma se na chin ka suyang khan kalaya I a local advocate han assist tir ngai ang chi han associate ngai ang chi te kha Guwahati high court rules ina kan lo ne anga rules dangan lo ne ve chon ka ting te kha lo ngai ta maro chu sorzim te le Mizoram a chuan kan du duin kan kalpe pot kha chuan kan man chuan kan an ding thei ni chu vel chu khalai kha chu fi aming ka ria mai nga khatro my name ani boka fi deun kan
osar karetiam I nia karil ruat thil pakhat lom le chu ne hai tian in kan zirti tu te yan than fel ta July te mian ngai sakta kan malam hun kan future hi mian thlir pui thiam ta offline kan kalthin lai pon I ka hlok na ber pakhat ni thina lecture rang te zir top Friday ate hanin ange chang hen khat moi tok khen program kan nei reng thin ta cho mi dang anon kal thin ta tu soi te bo ngai thla thin ta ni chung zinga chonin inel om ria kanel nel big rio ching garia inel om big rio garia alomum ti tak zeta nge ka zona le chu tun han ke ni lo zir ka lo zir chuak ve don ta all India bar exam kan la thu don ta lo ta ni chu ta chonin kan lo exam chuak ve ni chuan ko ta go tia kan zu pen register ve mon ye nga khami chung khan junior in enge ti thei kan nei tinan kan enge senior te kan lo zui ta chonin hey kan senior chuak ta chiat na te pokhanin enge an mani ming chuan an la ding thei lowa amaro chu silte kan siam tira chuan enge ino te pokan nei ya ko ta te pokan ding ve thu ti te kha an sui ta ni khala khan enge khami bar exam la thu lo te kha enge ti thei kan nei ve la ya kha khomai in
emi ama kan bar secretary kan ilai hi chuani dana in thak to em ka relowa emi bar enrollment tan su ti hian AIB thu lo ngai ta an thu ma kan affidavit declaration ang kan kum ni nge o AIB and thu ma ka chon kum ni mo ka practice theini tlating ka riani chuwan chon kha wang tak khan an lo practice ve the khani ta ni amaro chon pass chun zom lo chon AIB and thu lo chon an ti chun zom thelo me nga ti khani a dan la ding renga ni chon ka tiang vel khani ta in enrollment ti hian khulai kon an boy fo me ni boy ne chon khu tuna he chon he high court ron kal thang PD nair te poi vice chairman te ni midang tam takpo kan phone sakati khanin chu te chu kasoi additional down kan soi me ni chu lo lungai lo la khatianga chon enrollment ten su tinga ahar sani chuan thian te pawh kan nei nga huta kanin phone sakanga atlang zot me ang chun te chu har lo tura ngai la tin in lo ti thei tia chuanin nia hey ke po kha ati esirmi alon class voi khat ma kal loin ka kan hel nuai chowa ma se ka zir hu ni chu ka practice tan ren ka zir chau zok ka ti tak tak ge chu ka tiang ha nang ni chu tu na in zir na ye tha ka ti to pe tiang hian engkim nge arrangement ten siam tha ka te in zir te tu te pon chu ti la ya chuan amaro chu practical don ta litigation practice line litigation in kal don chuan chu ta tak chuan atira chuan beidon thak chang tamania junior law firm phaya de chuan law firm an lut me ya law firm pa ngai taka engemo in administration fel tak ne ya te nangni chuin ron kalanga zui turin zonga anlo khat thup tong chu ta tak chuan a beidon thak tan na in tan ta chi ta ni ik taka chuan kebo min ron deal cham chi ei kan tam to si kan thanem to si ti khan hreom takin narzel an nga ya khata tak khan strong ngai ve ta ni tin chu mai baka ti mai me a atir struggling period anga te chuan I tam tak chun duam ngal ringota land acquisition case ti kan ten zonga ti khan an zina kha thiam na ni lo ti hriat tur chu ka soi tel me du ni kan sarmon lok ngare lo te chulai chu apoi mo chu case neyat le senior bula oma observation good observation nei tum tur ani lo chuan atir tang in hel noi chuan in bo kui thakanga top thlengin in duam na ei puram zau bula om thina tuna chuan chief minister advisor anita ka chuatan vedon chu ge pok chuak ma deu ka india ngaro chu min phil chu ma engi chu vedon ta ga chuan hei lo rengla first learn and then earn first learn and then earn tia I chuak ani chuan in iding chuak anga ma se first earn and then learn ani chuan iding chuak long min ti adik ka ti khop me chu ke chu engma ka ni chuang lo na hei I ka thiame in ti thei ka ni mi lo ma se ka von reng chu alo dik ka ti chu wan chuan en han experience chu ti te chema ro pui tak soi tur chu ka nei lo na ma se ria ula ka du chu khala e kha poi mo ka ti tlata du am na ina tran ngala earning ina tianga kan lo ka lo nei vat nan eng tinge niang ti te chu ke kan nei tur ani adika kan chung te pon ke po opil ni nuwa chu in khom tung tra te na mu the tin min la sei min la di sak char cha se ka te kha atheng ngai ka tiang ka chuan nang wani apo du am na le sum khan tran lo se earning khan tran mas kher su se ti ka fui ve du la cheu ni tin chu ta po chuan nakina bar in that thot chuan in teima po chuan tun hle yen ka en thina mi junior te ani hi a boy wa lo chuan nakina hei chu kala hawang ti ril ru te poi ka nei ve fo ni achan chu ka khan time mangai tam tak chu tu na jong kan film phur to mi enge athiamem a sincere em ti khelo chuan kan la du top to mi lo ni law firm te pon chuan Kevin a subject to in David sonom deu ma se kan soi ni chu ole puina pa in
alo mo poi mo lu tok kha ni thil poi mo takani ukil ne na changa free advice kan don thei lai kha chuan in opportunity kha grab char ro ga ti khamo time is money ani kha midang zo na pani khat kan hong le lok nga to lo chuan in conclude lama kan hnai to nga zo na han zo du engemo han soibel du nei kan la omem o kan zir lai te changin relo te kan hong lenga pani khat kan ngoi ang reng ma kan to lo ani ka ringa I ni china kan zir lai ma enga zok ngo ina aron se kha ni tihanin special academic program te po kan leya tikhanin program Friday tin te hi kan wat sai china offline mo online kan kan nu po hian chuta asoya khanin khanga kan resource person to zong zonga chanin kan nel ber ni ti angkha ke po kan soi ve de longa sang ni som pani atang khan kan practice puram zawate hnuaya tho kan pumarin ate uma enga hi kan nel masak ber polanya mi elo welcome ma chu chaina shan pai in share lok na po kan nil mar chu korta engeni a conduct le behavior tele a junior te in kol dan tele an ma ni shim ma khanin I kan nel masak ber polanya uma enga hi u pu ang po neron u ang tak tak kan ina ne kini ang generation kha chani khang hun lai tuna anau te roshana te hoten en hanin enrollment kan zo ti ho khani a I zanina po I mingai poimo a ka nge ni hun lu tak sengin soito ang khani hun che takara Asia zong pe chu soidon se chu I akar te po ngai mai theya mo chu ti khop chanin experience lo nga to te nia tin I anunga aron thunna thela ki background picture mai mai lo ti nge tak vek ni ti kha soi sak to a nge ni AIR case report kan ti te khatian zong te kha library ni he zoom ten kan te google meet ten kan te he background pic sang lo than be the khang kha ani moi lo ti palange tak vek ania I asoi ang khanin I nge ni umay nga ke ma po ni personal tak ka move china po a practice pa azir mo ti tak ani atuna po lo ting berte jinga mi ani ren boka I zanina puma enga I hun hutak se nga kantan I ithiam na te ishiat angte minron shila wangin lom thu kan sainon le du ani le ti khan zanina kan hun man the chu ni sela I kan conclude ni mai sela kan lo me good night everyone
sir kan lom tu ka